Hello everyone, I welcome you all at Smarty Education. Today we have to start with elements of company law lecture number 3. But before starting the video, let me tell you that this is the last lecture of legal aptitude of your paper number 2. Then after that, I will start logical reasoning. But before starting the video, my first and last request to all of you is to please watch lecture till the end so you get the full conceptual clarity. So let's begin with the lecture. Let's revise what did we study in lecture number 2. Following all the topics that we studied in lecture number 2. We studied differences between company and different organization, in which we differentiated company with undivided family, partnership and limited liability partnership. Okay. Then we studied various other forms of company. How? Because a company has many forms like private company, public company and a government company and foreign company and many more. If you have not revised, go and watch lecture number 2. That was the most interesting lecture that I have ever made in my life. Okay. So now let's understand concept of corporate personality. But before going deep into the corporate personality, I have already explained you what is a corporate personality. So what is a corporate personality? Corporate personality basically means that a company is a separate legal entity from its individual members. It is an artificial person under the eyes of law and carries same rights as a person, natural person has. Okay. You all know that company is a separate legal entity distinct from its member. That's already told you. The concept is that separate legal entities should only be used for legitimate businesses. So what do I mean by this statement? This statement basically means that legitimate. First of all, understand what is the meaning of legitimate. Legitimate means right. But for example, I formed a company named A Limited and A Limited has the work of selling shoes. But I am selling my personal car to the company and the car cost only 2 lakh and I am selling to the company for 10 lakhs. So will that be a right use of my company? You will always say, no sir, you are selling 2 lakh car for the price of 10 lakh to the company. It's a wrong use of your company. So what will happen if I do that? When a fraudulent and dishonest use is made of the legal entity, the individual concerned will not be allowed to take shelter behind the corporate personality. If anything goes wrong, then personal people will be liable for the company's act. The court will break through and apply lifting or piracy through corporate will. It means that court will apply this principle and separate legal entity will be snatched from the members and whoever is informed in the wrongful act will be liable. Okay. Let's understand the cases in which court can apply piracy through corporate will. Okay. When the commission has been involved in fraud or improper conduct. So let's understand this with a very famous case study. Let's assume that A and B enter into the contract in which A will sell his house to the B. It's a very good looking house you are always seeing on the screen. Okay. But later on A said to B that I have sold the property to the company. Now here is a twist. Okay, but in the company only a clerk and he was the only member. So what do I mean by this? Means 99% of the shareholding is held by A. So can I say that for his own personal benefit of not to sell his property to B, he sold his personal property to the company created by him. Okay, now since B always wanted that particular house, B sued A for specific performance of the contract. Both of them went to the court. In this case, judges said that A has misused the company's separate legal entity. How? Because he sold his own personal house to the company for his own benefit for not selling the property to the B. Okay, by transferring the property for his own benefit. So the court will apply piracy to corporate will and will make liable A and will punish A. Okay. So that was the first. Let's understand when corporate will is lifted when company is regarded as enemy character. First of all, understand what do you mean by enemy. Enemy means something who is in opposition. Narendra Modi versus Rahul Gandhi. Okay. So corporate will is lifted when company is regarded as enemy character. Let's understand this with a very famous case study. In Daimler Co Limited versus Continental Tire and Rubber Co Limited, it was proved when company is regarded as enemy character, its corporate personality is snatched. Okay, let's understand the case study. So there was a German tire company named Tire and Manufacturing. It was a company based in Germany. Okay, it set up a company named Daimler in England. Okay, so it incorporated a new company in England named Daimler. Okay, 99% shares of Daimler were held by German citizens. Okay, Daimler did a lot of business with Continental Tires. This is the another company, Continental Tire, in which Daimler did a lot of business of selling tire to the Continental Tires. Okay. Then World War I started in which England and Germany were enemies. Okay, in which England and Germany were enemies. So what happened next? Okay, at that time Daimler demanded the payment for the tires that were supplied to the Continental Tires. Okay. So what did the Continental Tire said? But Continental Tires refused to pay, so as Germany was an enemy of England. Okay, if Continental Tires had paid amount to the Daimler, then it can be regarded as helping the enemy in the world war. Okay. So since Daimler said that I have a corporate personality, I am a corporate personality, how can you help German citizens in it? Approached the court saying that it's an England company because it was incorporated in England. So what happened in the court? The court said that 99% of shares were held by German citizens. So can I say that it's a German company? Yes, of course. So Continental Tire cannot pay at this time. Here in the case, corporate will has been lifted, in which company was not recognized as separate legal entity until the war ends. Okay. Now let's understand when corporate will is lifted. When company's sole purpose is to avoid tax. Let's assume that there is a company named A Limited, formed another company B Limited in which earns a lot of profit, assume that A Limited has a subsidiary company B Limited. Okay, and since here is the state, profit earned from B Limited is not shown in books of A, so it was successfully avoid paying more bonus to worker. Here it is avoiding to pay tax as well avoiding to pay bonus to workers. So that is the wrong use. Okay. Other cases when corporate is applied, where a corporate facade is really only an agency instrumentally. Okay. When the doctrine conflicts with public policy, court lifted the corporate will for protecting the public policy. So what do I mean by this? Basically, it is concerned with public policy. If a company prohibits public policy, then corporate will is lifted. When it is found that a company abused its corporate personality, means misused its corporate personality for an unjust and equitable purpose, the court would not hesitate to lift the corporate will. Okay. Now let's talk about journey of Indian company law. How the Indian company law is being formed in India. Okay. So the first Companies Act of India was passed in 1850 for the registration and transferability of share by the British government. Okay. Companies Act 1956 was passed on first. Our Independent Company Act was passed on 1st April 1956, which contains 658 sections and 15 schedules. Okay. Let's talk about concept paper on company law, how it was being drafted, and 2004 and J.J. Irani report. Okay. So the government first of all invited public to give their suggestion for the new company law. When government was framing the new company law, government basically invited public to come and give their suggestion related to new law. Okay. The government then formed committee headed by J.J. Irani on 2nd December 2004. The government basically formed a committee to give valuable suggestion under the head of J.J. Irani on 2nd December 2004. Okay. The committee submitted report on 31st May 2005. The committee suggested following points to be drafted in the new company law of India. The report of the committee had also sought to bring multifarious, progressive and visionary concept and endeavored to recommend a significant shift of government approval regime to a share approval and disclosure regime. What do I mean by this? First of all, basically earlier this was used to happen that government used to approve many things for a company, but now the report said that it should be on the hands of shareholders. Okay. The next is the expert committee had recommended private and small companies need to be given freedom in operation and flexibility in compliance cost. Now let's talk about Companies Bill 2012. The Companies Bill 2009 was introduced in the Lok Sabha on 3rd August 2009. The Companies Bill 2009 after introduction in Parliament was referred to the Parliamentary Standing Committee on Finance for examination, which submitted its report on 31st August 2010. Certain amendments were introduced in the bill and the light of the report of the committee and revised Companies Bill 2011 was introduced. This version was also referred to Honorable Committee will also give suggestion which suggested certain further amendment. The amendment bill was passed by the Lok Sabha on 18th December 2012 and the Rajya Sabha on 8th August 2010. Remember the dates, this can be asked in MCQ. The bill was retitled as Companies Bill 2012. Okay. Now finally the Companies Bill 2013. The Companies Bill 2012 finally became the Companies Act 2013. It received the assent of the President on tell me the date, on 29th August 2013 and was notified in the Gazette. Means received assent of President on 29 August 2013 and came into the force on 30th August 2013. Remember the date, this can be a very confusing thing. Okay. It includes associate company, one-person company, small company, dormant company, independent director, woman director, resident, all the many etc. So okay, you will read after pausing the video. Okay, now let's talk about applicability of Companies Act 2013. According to section 1 of the Companies Act 2013, the acts extend to whole of India and the previous version to the whole. Means the registered company which are under Companies Act 2013 as well as those who are registered under Companies Act 1956 will be applicable to the Companies Act 2013. Companies incorporated under this act or any other previous company law, insurance company except insofar the stat provision are considered with the provision. Means insurance company will also have to follow Insurance Act 1930 and also have to follow Companies Act 2013. Okay. That is Insurance Regulatory and Development Authority Act 1990 also to be followed. Banking companies except in so far the stat provision are inconsistent with the provision of the Banking Regulation Act 1949. Means either you follow Banking Regulation Act or Companies Act 2013. Okay. Companies engaged in the generation or supply of electricity. Okay, and also be to be followed Electricity Act 2003. Okay, any other company governed by any special act for the time being, except in so far as that provision are inconsistent with the provision of such special act. Okay, such body incorporated by an act at this time being in force as the central government may by notification specify in behalf subject to such exceptions, modification or adaptation may be specified in the notification. Okay, what do I mean by basically this? Such body incorporated by any act for the time filled by central government will be updated by this notifications. Okay. According to section 454, a partnership can only have 100 partners. So MCQ can also be made. What is the maximum limit of partners? That is 100, and which prescribed by which act? It is prescribed by Companies Act 2013 and is not applied to Hindu undivided family, an exception. Okay. Okay. So now let's understand about share capital. Very important concept. Let's say you want to start a fruits and vegetable shop, you want to start a grocery store, you want to start an ice cream parlor, you want to start a coffee shop, you want to start a milk shop, and you want to start a bookstore. So sir, why are you asking us all this? So before going to asking, so what do you need for starting them? You want to own a fruit shop, you want to own a store, you want to own a milk shop, etc. Okay, so what is the thing that you need for starting them? Okay, so your answer will be money. The only thing that you will need is money, and the money invested is the business is known as capital. So whenever you start a business, you apply or invest some money in the business, and that money is known as capital. Okay, so when capital is obtained by company in the exchange of ownership, it is known as share capital. Okay, let's assume that A and B formed a company AB Limited and registered authorized capital of 60 lakh in memorandum of association. Means beyond this 60 lakh, company cannot raise any amount from the public. Okay, then they issued 2000 shares worth of 1000 rupees to public to get 20 lakh. So it is known as issued capital. So what do I tell you till now? What did I tell you? What is authorized capital? Beyond this limit you cannot raise the fund. And what is issued capital? That is issued to general public, that is known as issued capital. Okay, means 2000 into 1000, that will be also known as 20 lakhs. Okay, the public applied for 1900 shares and it is known as subscribed capital. So whenever public will invest in the money, it applied for 1900 shares, means company has obtained 19 lakhs. Okay, no 18 lakhs. Sorry, my maths is wrong, so comment down below. Okay, so it is known as subscribed capital. So till now what did I tell you? Authorized capital, issued capital, and subscribed capital. Authorized capital means you cannot raise after 60 lakh. Okay, issued capital means applied to general public, and subscribed capital means how much the public has subscribed to your shares. Okay, I hope you got a very good understanding related to it. Okay, so now the amount which is paid by the public is known as paid up capital. So whatever the share amount is, it is known as paid up capital. Okay, their part of capital which is demanded by company means whatever payment the company will demand is known as called up capital. Okay, now let's talk about types of share capital. The first one is equity share capital. Equity share capital with reference to any company limited by share means all share capital which is not a preference share capital. So what is preference share capital? Preference share capital with reference to any company limited by shares. So what do you mean by limited by share? Means the owner's liability will up to the amount that he has paid to the company. Means that part of issued capital of company which carries or would carry Preferential rights with respect to payment of dividend either is fixed amount, means what are the advantages of preference dividend, that is basically described here. Okay, payment, like preference shareholder will get payment of dividend either as fixed amount or an amount calculated at a fixed rate which may either be free or subject to income tax. Okay, next benefit enjoyed by preference shareholders, repayment in the case of binding means they will get first payment before the equity share capital. Okay, that is a preferential right in the payment of any fixed premium or premium of any scale specified. Okay, I hope you got a very good understanding. If you have reached here, comment down present sir in the comment section so I can mark your attendance, and don't forget to join WhatsApp group. Now let's start with board of director. Who are known as board of director? Those people who run the company are known as board of director. Acting collectively are known as board, means those people who run the company are known as board of director, and directors acting collective means individually are known as board singularly. Okay, now let's talk about board of directors. Section 2 subsection 10 of the Companies Act 2013 defines that board of director or board in relation to company means the collective body of the directors of the company who will be responsible for the running of the company. The term board of director means a body constituted to direct, control and supervise in the affairs of the company. As per section 149 of the Companies Act 2013, the board of directors of every company shall consist of individual only, means a firm cannot become the director of the company, means a company cannot become the director. Okay, as per section 149 subsection 1, in a public company minimum 3 director, minimum how much? Minimum 3 director is required. Okay, in private company minimum 2 directors are required. In one person company minimum 1 director are required. Remember this, very important for your MCQ examination. Okay, a company can have more than 15 directors after passing a special resolution as per described in section 149. One director should be stayed in India for not less than 180 days. Okay, I hope you got a very good understanding. Okay, now let's understand appointment of director, how a director has been appointed. As per section 152, if nothing is mentioned about director appointment, then initial subscribers will be the directors of the company who will initially invest in your company. A person shall not be appointed as director until and unless he gets a director identification number. Okay, a person appointed as a director, shall not act as a director unless he gives his free consent, means he should be agreed to become a director, and such consent has been filed with registrar. Within 13 days we should be registered that he has given his consent to become a director of a company. Okay, unless the articles provide for the retirement of all the directors at every general meeting, not less than 2/3 of the member of director of a company shall be person whose period of office is liable for the determination of the director by rotation. Okay, unless and until article doesn't say anything, either the director can be retired by rotation, means after a time period, save as otherwise exceptly provided in the act, be appointed by in the general meeting. Either a director can also be appointed in the AGM, annual general meeting of company. The remaining director in the case of any such company shall, in default of any subject to any regulation article, also be appointed by the company in general meeting, means director can also be appointed in the annual general meeting of company. Okay, at the first annual general meeting of a public company held next after the date of the general meeting at which the first director are appointed, means what will when the directors are appointed after the first general meeting. In accordance with the clause A and B, at every business subsequent annual general meeting, 1/3 of such of the director for the time being is liable retire by rotation. I already told you. Or if their number is neither 3 or multiple of 3, then the number nearest to 1/3 shall retire from the office every year. Okay, the directors to retire by rotation at every general meeting shall be those who have been longest in office, means those appointment are the last, means they are very old. Okay, between person who became director on the same day, those who are retired shall in default and subject to any agreement among themselves to be determined by lot. Okay, the next thing is, at the annual general meeting at which director retires aforesaid, the company fill up the vacancy by appointing retiring director or some any other person. If there is a vacancy, either the existent or the resigned director can be appointed, means the same director can also be appointed, or any other one can also be appointed. Okay, now let's talk about how a director can be removed. Removal of director, a company may by ordinary resolution remove a director not being a director appointed by the National Company Law Tribunal. So here is the exception. If NCLT means National Company Law Tribunal appoints a particular director to measure the activity of the company, then he cannot be removed by passing an ordinary resolution. But if the director has been appointed by the company, can be removed by passing an ordinary resolution. Okay, before the expiry of the period of his office after giving a reasonable opportunity of being here. Means what do I mean by this? Before removing the director, he can also be given an opportunity of being here. Why should he not be removed? Okay. An independent director reappointed for second term shall be removed by the company only by passing a special resolution after giving him a reasonable opportunity. Means to give him justice why he should not be removed after being hearing. A special notice shall be required of any resolution to remove a director under this section or to be appoint somebody in place of director so removed at this meeting at which he is removed. Okay. A vacancy created by the removal of director may, if he had been appointed by the company general meeting or by the board, be filled with appointment of another director in his place at the meeting at which he is removed. So whenever the old director has been removed, new director has to be appointed either at annual general meeting or at any other place. Okay. A director so appointed shall hold his office till the date up to which he is a predecessor would have been held office if he had not been removed. Means if a director has to be a director till 31st December, then he can hold his position until unless till 31st December. Okay. Then the next one is meetings of the board. What do I mean by meetings of the board? When shareholders will meet with each other. Meetings of the board are significant in the light of running this company more efficiently and effectively. Companies Act 2013 mandates a company to hold minimum number of meetings of the board for its proper functioning. Companies Act provides that the first board meeting should be held within 30 days of incorporation. Thereafter, there should not be gap of more than 120 days and minimum of 4 meetings should held every year. Okay. In case of one person company, small company, dormant company, one board meeting should be conducted in half of the calendar and the gap between 2 meetings should not be less than 90 days. Okay. Board of Directors of Section 8 companies shall hold at least one meeting within every 6 calendar months. Means whatever company are registered in Section 8, they have to hold a meeting within every 6 months. Okay. Now let's talk about shareholder meeting. There must be at least 2% to constitute a meeting. Okay. But in certain exceptions, even one person may constitute a meeting. It is to be noted that every gathering or assembly doesn't constitute a meeting. For example, you go and meet the shareholder at a coffee house, that cannot be a meeting. That will be an informal meeting. Company's meeting must be conveyed and held in a perfect compliance with an arrangements. Okay, and the rules framed under the Companies Act 2013. Annual general meeting is an important annual event where members get an opportunity to discuss the activity of the company. Convening of one such meeting every year is compulsory. Okay, annual general meeting, like you have also heard that Reliance has conducted annual general meeting. Okay, annual general meeting should be held once in each calendar year. Subsequent annual general meeting of the company should be held within 6 months from the date of closing of the relevant financial year. The gap between 2 annual general meetings shall not exceed 15 months. Means within 6 months you have to hold the annual general meeting and it should not exceed 15 months of time period. Okay. Now an annual general meeting is also called business hours. Remember MCQ, and this is between 9 AM and 6 PM. It should be held at either at the register office of the company or at some other place if your register office is not big enough to hold all the shareholders. Okay. The central government is empowered to accept any company from this provision if a government permissions that. According to section 102 subsection 2 clause A, in the case of annual general meeting, all business to be transaction thereat shall be deemed at other than the consideration of financials and the report of the board of directors. Means in case of annual general meeting, all business to be transaction thereat shall be deemed special other than, means all business transactions shall be deemed other than these first point and declaration of any dividend. Okay. The appointment of the director in place of those retiring should be considered annual general meeting. The appointment of the fixing and remuneration of the auditor should be fixed in annual general meeting. Section 99 of the Companies Act provides that if any default is made in complying or holding a meeting of the company and every officer of the company who is default shall be punishable with fine which may extend to 1 lakh. If any company commits any faults in this regard, 1 lakh rupee will be fined, and if you didn't pay that fine, 5,000 rupees fine will be for every day if you are violating that rule. Okay. Now let's understand corporate personality. Okay, sorry, corporate social personality. Now, do you know Reliance spends too much on charity, that is referred as social responsibility? Like you saying that Reliance Foundation health camp has been organized to help the society, because the company obtains everything from the society to give a back something to society. So whatever you earn from, it's from society. So if you help the society in the form of company, it is regarded as corporate social personality. Okay, now let's talk about corporate social personality. Okay, so every company having net worth of 500 crore or turnover of 1000 crore or more profit of 5 crore deemed preceding financial year shall constitute a corporate personality. Means three or more directors, out of which at least one director shall be an independent director in the board of committee of consisting of corporate committee of corporate social personality. Okay, the board shall disclose the composition of the corporate social responsibility. The corporation of social committee shall formally recommend the board social responsibility possibility, which shall indicate the activities to be undertaken by company in areas on the subject specified in schedule 7. Means the corporate personality board can suggest suggestion in the schedule 7, that is written in schedule 7. Okay, recommend the amount of expenditure to be incurred on the activities. Means the board of committee that is responsible corporate social responsibility can also give suggestion regarding expenditure to be incurred on these activities. Okay, monitor the corporate social personality policy of the company from time to time, whether company is spending on that particular thing or not. Okay, now let's move on. The board of directors of every company shall ensure that company spends it every financial year at least 2%. Means 2% is necessary to spend on social responsibility of the company of the average of net profits, and 3 immediately preceding financial year, or where the company has not completed the period of 3 financial years since its incorporation during such immediately preceding financial year in pursuance of its corporate personality. 2% is necessary. Okay, to give a corporate personality. In case the unspent amount doesn't relate to any ongoing project, means the project is to be held in future, so that particular amount is to be transferred to the fund specified under schedule 7 within the period of 6 months due before the expiry of financial year. In case of the unspent amount relates to any ongoing project, means the project has been going on and the amount is to be spent to fulfilling prescribed condition, unspent amounts to be transferred by the company within a period of 30 days. 30 days, remember, from the end of the financial year to a special accounts to be opened by the company in that behalf for the financial in any scheduled bank, that will be called as unspent amount. If the amount has not been spent and is in the progress of spending, then it will be transferred to the unspent corporate responsibility account to show that to the government. Okay, penal provision under. What will be the penalty if you violate these rules? The company is punishable with fine which shall not less than rupees 50,000, which may extend to 25 lakh rupees if you violate these rules and regulation. Every officer of such company, means who is preventing to spend on corporate social personality, may get a jail of 3 years, or which shall not be less than rupees 50,000, but which may extend to rupees 5 lakh, or with both. Okay, corporate social personality activities, this can include the activities like that, please read them. Now let's talk about business ethics. Business ethics refers to the implementing appropriate business policy and practices with regard to arguably controversial project. Basically, understand first of all what is ethics. Ethics basically means wrong or right. Okay, so business ethics refer to implementing appropriate business policy and practices with regard to arguably controversial subject. So let's understand this with a very good example. Some issues that come in the discussion of ethics should include corporate governance, insider trading, discrimination, social responsibility, and fiduciary responsibilities. Okay, an example of business ethics is when moral rules are applied. Means there should be when moral rules are applied by corporation, which are how best to treat its employees. Moral rules means you have to help each other. Business ethics basically means doing the right things with the form of corporation. Okay, shareholder and customer. An example of business ethics are accounting ethics. Means ethics should be followed. What is right, you have to follow it. That's basically meant by ethics. But I think that no question can be asked from business ethics, so don't worry about that. Okay, so thanks for watching, guys. Now let me tell you that if you join my WhatsApp group, what are the benefits? Free mock test series that I'm going to start very soon, 8 AM to 9 PM doubt session. You can message me anytime. Daily current affairs PDF I am sending on the group, and July whole month current affairs has been sent. So if you have not joined the WhatsApp group, please join and get the benefit. So subscribe the channel and like and share. Goodbye, guys. I hope you have